88, Representative Thapedi. Mr. Clerk, please read the bill.
House Bill 188, a bill for enacting civil law, third reading this House bill.
Representative Thapedi.
Thank you, Mr. Speaker. House Bill 188 is the Civil Litigation Reform Act. This bill restructures Section 301 of the Illinois Code of Civil Procedure to ensure that justice is done to all defendants, especially pro se defendants, who are not properly served in litigation but still are hit with default judgments. This particular issue was overlooked in 1999 when we did away with special and limited appearances. And at this point, Mr. Speaker, I want to make clear that these issues often happen in mortgage foreclosures actions and in lesser exposure litigation where judges are quick to find waiver of jurisdictional challenges by defendants. I've personally seen judges strip away rights and homes on this issue. This bill allows an aggrieved defendant to first and foremost attack a default judgment. If he or she is successful in obtaining the relief from the default judgment via a 1301 motion or a 1401 petition, he or she may then lodge a jurisdictional challenge relating to the improper service if brought within 60 days of resolution of those two types of pleadings. Under current law, first moving to vacate the default judgment would waive the right to lodge the jurisdictional challenge because only a motion to extend the time to answer or otherwise plead would be allowable in this scenario. This is an anomaly in the law, and this bill actually cures that. In the event that an aggrieved defendant does not initially move for an extension of time to answer or otherwise plead or relief from a judgment under 1301, 1401, or 1401.1, that defendant prospectively waives those objections, and this is consistent with the Mitchell case that was decided by our own Supreme Court in 2014. I want to personally thank Chris Hurley and his plaintiff's trial lawyers, Jim Covington and his ISBA lawyers, Mark Mifflin and his defense trial lawyers, Steve Olson with the lenders, Dave Manning with the creditors bar, with their swift work on this important issue. There are no opponents to this litigation that I'm aware of. The intent is for this act to apply prospectively to cases that are filed immediately after an enactment. And they also, Mr. Speaker, that the legislative intent of this particular piece of legislation is to ensure that BAC Home Loan Servicing LP versus Kim Mitchell, a 2014 7-0 Supreme Court decision, is still good law. I'm available to answer any and all questions.
Further discussion, Representative Anderson is recognized.
Thank you, Mr. Speaker. Will the sponsor yield?
The sponsor will yield.
Representative, we worked pretty hard on this in committee. As I recall, one of the objections to it was the retroactivity. Yep. I believe you said it, but I want to be clear. With the third amendment, we made clear that this is prospective only in nature, correct?
Yeah, exactly right, Steve. I mean, and that was the last amendment that we did. The idea was initially, you'll recall that initially we looked at the waiver being both prospective and retrospective. We looked at the Mitchell case again, which again, as I said, was a 7-0 Illinois Supreme Court decision that made clear that retrospective waiver would not be appropriate. That's why the bill now is only prospective waiver in those scenarios. And
as a result of that, I believe that all objection was removed from the bill?
All objections have been removed.
Thank you very much.
Thank you.
Representative Thapedi to close.
I urge and I vote.
Question is, shall House Bill 188 pass? All in favor, vote aye. All opposed, vote nay. The voting is open. Have all voted to wish? Have all voted to wish? Have all voted to wish? Mr. Clerk, please take the record. On account of 113 voting yes, 1 voting no, 0 voting present, House Bill 188, having received the constitutional majority, is hereby declared passed.